Welcome to our tutorial today. My name is Sharon Chahale Wata. I'm the Assistant Director, Legal Affairs from the Kenya Copyright Board. Today I want us to talk about copyright as intellectual property and differentiate it from other forms of intellectual property. We start with what is intellectual property. Generally, intellectual property refers to property resulting from the fruits of the mind. Just as you can have a car, you can have a house, you can also own property from what you have created with your mind. That is what in law we call intellectual property. Intellectual property itself is divided into different forms. We have what we call industrial property, and then we have copyright. Industrial property covers different things. I will just mention a few. We have patents. Patents usually would cover inventions or creations, okay? So you're having a product or a process of making something. For example, the process of making soda, the process of making soap, that can be patented. Then you have trademarks. A trademark is a sign that would distinguish goods and services of one person from goods and services of another person. When you look at a trademark like Coca-Cola, for example, you're able to tell that these goods and services are from this company as opposed to coming from another company. You also have what we call industrial designs. These really are the ornamental aesthetic aspect of an article that is protected under law. We also have what we call geographical indication. Basically, these are signs used on products that have a specific origin in terms of location, and usually it would also speak to the quality of that product. For example, you may have a wine coming from Italy or from South Africa. It would have a specific sign so that the moment you look at it, you're able to tell that this wine is from South Africa, this wine is from Italy. Now we come to copyright. What is copyright? This is a legal term that we use basically to describe rights that creators have over their works. What works are these? These are literary works. When I talk about literary, we are talking about novels, books, plays, scripts, works that are written. We have musical works, songs that are performed, songs that are written down. Those are the musical works. We also have artistic works. We're talking about photographs. We're talking about paintings. We're talking about carvings and crafts. Then we also have computer programs and software that are covered under copyright. We also have architectural designs that are covered under copyright. Now, the protection of copyright, basically, we say it protects what you have expressed as an individual as opposed to what's in your mind. So we say it doesn't protect ideas, but protects the expression of that idea. Now, there are two types of rights that copyright gives you. You have economic rights, which allow you to derive some financial reward from your work. Then you have moral rights. Moral rights protect your non-economic interests in the work. Some of the rights that copyright gives you as a creator is you are allowed to object or control the use of your work in terms of, one, reproduction. If you're a musician and you have a CD music out there, somebody who wants to reproduce must ask you first. You have public performance. If you want to perform somebody's song in public, you must seek the permission. You have recording, broadcasting. You have translation, adaptation. If I write a book in English and someone wants to translate it into German, they need to ask for the permission from me. Now, the moral rights basically are rights that you as an author can claim authorship and ownership to that work. Number two, you can also oppose changes to that work that would hurt your reputation. For example, if someone wanted to change your work and use it in pornographic material, then you have the right to object to that. The other thing we need to know about copyright is that the term of copyright would last usually 50 years after the death of the author. Thank you.